Hello everyone, and welcome to this online version of our Russell-Cooke free seminar series for charities. As you can see, I'll be presenting on changing the use or occupation of your charity property. This is part of a series that we've called Exiting Lockdown for Charities. My colleague Carla has already presented on the employment law aspects of going back to work, and you can find that on our Russell-Cooke YouTube channel. My colleague Gareth will be presenting on incorporation, so look out for an email from our marketing team on that. This is being recorded, so if you want to look at it again, or if you have any colleagues who'd like to look at it, they can find it on the Russell-Cooke YouTube channel. There's also the opportunity to ask questions in the Q&A panel. That won't form part of the YouTube video, but if you're watching the pre-recorded version, you'll find my contact details on the final slide, and I'd be very happy to have a call or answer a question by email using those contact details. So without further ado, we know that charities are considering or reconsidering their use of property in the light of COVID, either as a result of diminished resources or because of increased home working, or just it's prompted them to think about property. I've set out on the slide some of the things that you might be thinking of doing with your space. I won't go into that in detail now. I'm thinking in this talk mostly of operational space, which is probably likely to be held by tenants for most charities. Although, because I'm starting from the sort of generic headline level of things to consider, a lot of things at that level will be relevant to a charity landlord planning to let property as well. So hopefully it's relevant for all of you. So I've set out on this slide the things to consider as your sort of checklist for any of the things that I mentioned on the previous slide. I've done it on the basis that I start at the most generic headline level and then work down to things that are going to be more specific for specific transactions. And I'll follow that list as I go through. So starting with your constitution, you have a duty to do things which are either within your charitable objectives or ancillary to them, and to act within your powers. If not, then your charity trustees could be held to have acted outside their powers, ultra vires, and thus be liable to account to the charity for any loss, account personally for any loss incurred as a result of that action. So if you're thinking of doing something like changing your use of the property, the activities you carry out from there, collaborating with another charity on a non-commercial basis, then you should check whether that's permitted by the objects themselves, and also by any geographical restriction on those objects in your constitution. If it's not authorised by your objects and you still want to go ahead and do it, then you should approach the Charity Commission for permission to change your objectives. There may also, with particular properties, be special trusts attached to the property, particularly if you're a charity, which are very specific about how it should be used and really restrict the ability that you have to dispose of it. I won't go into too much detail on that, because for most charities it won't be relevant, but it's just something to bear in mind if you see a restriction in the title deeds or in your constitution. You should also make sure that you have power to do the thing in question. So for example, if you're thinking of subletting or assigning, i.e. transferring a lease, then you should check that you have a power to dispose of property. If you're a charitable company or a charitable incorporated organisation, you probably already have that power, or if you don't have it, you have the ability to amend your constitution to include it. If you're a trust or an unincorporated association, particularly if you're an old one, then you may have almost nothing in your constitution about your powers. In that case, you may be able to rely on the implied powers under the Trustee Act 2000 if you're a trust, which basically say that you'll have all the powers of an absolute owner, which would include disposal. Or you may be able to use Section 280 of the Charities Act 2011, which allows you to pass a resolution to amend your administrative provisions, which will include powers but not objects. Then I've lumped a lot of things together in this heading 2 on this and the subsequent slides, just because I thought they were all sort of at a similar level in the process. So starting with your land registry title and title deeds, either you will occupy under something which is registrable in its own right and has its own title. So you have a freehold building, or you have the freehold of the building, or you occupy under a long lease, which over 7 years, which is registered in its own right. However, even if you occupy under a shorter lease, you're pretty much subject to anything that's in your landlord's registered title, either directly or via the terms of your lease. So either way, you need to do this investigation. Property is either registered or unregistered. Most property is registered. You can find out whether your property is or isn't by going to the Land Registry's map search tool, typing in your postcode, and then you can see whether an associated title number comes up, in which case it's registered, or whether the space is just blank on the map, in which case it's unregistered. If it's unregistered, you'll need to consult any title deeds that either you or the landlord hold. If it's registered, then you can obtain a copy of the register for £6 from the Land Registry. So what does that investigation show? The first thing I've put on the slide is legal charges, also known as mortgages, although mortgages is quite a vague term and no one truly knows what it means. But anyway, a legal charge is basically the way in which either a commercial lender or a funder will have protected the underlying obligations in the loan or funding agreement that you or the landlord entered into with them. And the point of a legal charge is that it allows the charge holder to dispose of the property, sell the property and take the proceeds, or appoint someone to run things from the property and take the income from that if you or the person who entered into the charge defaults on the obligations in that charge. So it is quite important to make sure that you've complied with the underlying obligations. So the legal charges, you might, under a funding agreement, have very specific obligations, for example, for you to use the property personally, or to use it only for a certain purpose, or if it's more of a commercial lending agreement, then it might just be that you or the landlord need consent to disposals. So that's something to bear in mind. Then I've also mentioned preemption agreements. That's when someone has the ability to take a transfer back of the property for possibly even a very nominal sum if you try to dispose of the property to someone else. So this is usually only relevant for freehold properties, but it's worth bearing in mind, obviously, if you have that, then you can't dispose of the property to the person you want to dispose of it to. You have to offer it back to the person who can buy it, probably for very little money. Also, options, these are rights for people to take a transfer back of the property. For example, it might be someone who originally donated the property to you or leased the property to you, or it might be a grant funder again, if certain circumstances are met. So again, this would potentially, if the option is exercisable, if you change the use or stop using the property, then again, that could be quite serious. You might have to lose the property as a result of that activity. Then covenants are promises that you or the freeholder or someone else in the past made with neighbouring owners, which bind the property. Covenants can come in different forms. There are positive covenants, which actually oblige someone to do something, for example, to build a fence. And positive covenants will only bind the person who made the original promise. So they're less of a worry unless you are the person who made the original promise, you or your landlord. If the other option is that they are negative or restrictive covenants, i.e. they stop you doing something, and restrictive covenants will bind subsequent owners regardless of the fact that the subsequent owner isn't the person who made the original promise. So with covenants, the neighbouring owner can, if so minded, get an injunction to stop a particular course of activity or get damages in default of that. So they're quite serious. However, it's always worth looking at the age of the covenant, whether there's someone in the vicinity who would actually be able to enforce it. and also whether the risk could be covered by insurance. Then another thing that will be revealed by the title is whether there are any rights over the property. If there are, then bear in mind that if, for example, you're entering into a sublease or something with another party, you need to make sure that any rights you're granting there aren't going to interfere with these rights shown on the title. And finally, hopefully you'd be aware of this if you've granted a lease over the property, but the title will also show you whether there are any leases granted over the property, provided that the lease is either over 7 years and has thus been registered, or the tenant has registered their rights contained in a shorter lease. Again, I'll come on to leases a bit later on. Then moving on to the planning permission, you should also check the land registry's planning section of, sorry, not the local authorities planning section of their website, both to check the current authorised planning use of the property as revealed by planning permissions. That will ensure that, well, basically if you're planning to change the use and it means that it's a use that's not within the use class that's authorised for the property, then you'll need to apply for planning permission to ensure that you don't get enforcement action against you by the local authority. You should also check the planning permissions to see what conditions are attached to them. Sometimes these can be quite specific, limiting use to your charity, again, similar kind of thing. And so again, you should be complying with those. If you're planning to carry out any alterations to the property, then you should check whether it's listed and whether you need consent. Also, there are things that are a bit similar to charges or restrictive covenants that I mentioned in the title section just now, which won't be evident at the land registry, but will be evident on the local land charges register. So that's another register that you ought to search in order to work out whether there's anything at a planning level that the property is subject to. For example, it'll show whether the property is subject to any Section 106 agreements, which are basically agreements where a developer is told by the local authority that their development is going to cause various harms to the area or going to remove various good things from the area, and they agree to various obligations to mitigate that. So they might be, you know, positive obligations to have a nursery at the property, which might be your nursery, or obligations to pay certain sums of money. Those obligations will bind the property and most interests in it rather than just the developer. So again, it's worth being aware of those. An important point, obviously not relevant if you're a freeholder, but if you occupy under a lease, then it's very important to look at the terms of your lease. The main reason you should do that is because the freehold or your landlord always has the option to forfeit your lease, i.e. to bring it to an end. There are various steps along the process of forfeiture which might allow you to remedy the breach and avoid forfeiture. But obviously, if you're set on a particular course of action and the only way to stop your own lease being terminated is to stop doing that course of action, it would probably have been better to have just gone to the landlord and sought consent before you did that, rather than going to the level of hassle and then finding you can't do what you want to do. So in terms of things that might need consent under the lease, sometimes there's an absolute ban on doing certain things under your lease, in which case it's entirely up to the landlord whether they want to, despite the strict terms of the lease, still allow you to do that particular thing. Or there'll be obligations to seek landlord's consent, sometimes not to be unreasonably withheld or delayed, but not always. So the kind of things that might be either banned or require consent under the lease are changes of use, subletting to another party, or transferring, i.e. assigning your lease to another party, or sharing. And also there might be restrictions on alterations, including sometimes internal demountable partitioning, for example, you know, things that you might be doing as a result of COVID or to share with another party. I also mentioned earlier that you might have granted leases or licenses to other parties, and within those you may have granted them particular rights over the space, and you should ensure that if, for example, you're entering into an agreement with someone else to occupy the space, that any rights you grant them, well, that their arrangement takes into account any existing rights and doesn't interfere with them. And coming on to disposals generally, one of the things I mentioned on the opening slide was that you might just be looking to reduce your liabilities with respect to property, either by transferring a lease to another party, also known as assignment, or by subletting part or all of the space, or by maybe surrendering an onerous lease back to your landlord. All of these things count as disposals under the Charities Act and require you to comply with, in most cases, with the requirements that I've set out on this slide. That can be quite a pain because the qualified surveyors reports regulations that I've mentioned on the slide are very specific about all the things the surveyor has to do in order for the report to be valid. So, for example, they have to measure the space, advise whether it ought to be repaired, etc. And all of this stuff is very useful if you are selling a property. But if you just want to dispose of, just want to surrender a lease back to your landlord, it's quite a lot to go through, which isn't directly relevant to the particular transaction. For example, I've also said in the second bullet point on this slide that you have to advertise if the surveyor tells you to advertise, unless the report actually advises that it's not in your best interest. And of course, if you're surrendering your lease to your landlord, there's no one to advertise the property to. You just need to surrender it back to the person who granted it. So in that scenario, you should point that out to your surveyor. I'm sure they'd note that point anyway, so that they can actually advise you not to advertise the surrender. There are slightly less stringent requirements for leases of 7 years or less. So whereas in the previous slide you had to obtain a qualified surveyor's report, had to be in writing, etc. As you can see under this slide, the advice can come from anyone. It could be from one of your trustees or employees if you think they've got the necessary experience to give the advice. And the advice doesn't even strictly need to be in writing, although for evidential purposes it's probably sensible to record the substance of the advice in any minutes of the meeting. So it's worth bearing this in mind if you are trying to offload property, then it may be better to sublet for less than 7 years, just to avoid the hassle of going through a full qualified surveyor's report. Obviously, there'll be other things to bear in mind, including the terms of your own lease, so that it's just one thing to bear in mind. Also, if your main objective is to remove liabilities, get rid of a lease, for example, then do check whether it's got break clauses in it. That's by far the easiest, quickest and cheapest way of ending a lease, and it doesn't count as a disposal for the purposes of this legislation, so you don't have to go through any of these requirements if you're doing that. Yes, I've just put on this slide some of the exceptions. The connected person thing isn't an exception, it's actually, you can't use the sections that I've just shown you and instead need an order of the court or the Charity Commission. I just thought I'd put that in there. But things that might be relevant to you are letting to another charity at less than the best price reasonably obtainable, or disposing to another charity, or leasing to a beneficiary at less than the best rent reasonably obtainable in order to further your purposes. Those might be relevant to some things that you're thinking of doing. Another thing to bear in mind is that obviously if you're letting a defined space to someone who's going to have exclusive possession of that space, then that is in substance, in law, a lease, and you should call it a lease, and you should contract it out of the Landlord and Tenant Act 1954 so that you don't get into problems when the lease ends. If you're interested in the Landlord and Tenant Act 1954, I did do a talk what to do as a charity tenant when your lease expires, which is also on YouTube, which gives you an overview of the dire consequences for the landlord if the lease is protected, or the potentially dire consequences. So yes, so if it's a lease, then call it a lease. However, if you're planning to share space with another organisation. Then, and for example, you can move them around within the space, or you genuinely share the space and cross their area all the time, or they are in there in order to further your objectives, then the legal reality is probably more likely to be that it's a personal license to occupy, i.e. a right to be there, which doesn't amount to a lease. If that's the case, then it's quite useful from a Charities Act perspective, because a licence doesn't count as a disposal for the purposes of the Act, and therefore you don't need to comply with any of the requirements I've set out on the previous slides. Also, with a licence, as I said, it doesn't attract the protection of the Landlord and Tenant Act 1954, so that's another bonus, but obviously it depends on legal reality of this position on the ground. Following close on the heels of the lease versus license distinction is the question of tax. Generally speaking, if you are letting a defined space, then unless you've opted to tax the property, i.e. to recover VAT that you might have incurred on refurbishment of the property, for example, unless you've done that, then there won't be any ability, or you won't be required to charge VAT on the rent to your tenant. However, if what you're granting is actually non-defined space, so for example, maybe a desk space license, then that arrangement is likely to be subject to that, i.e. you'd have to charge VAT to your occupier, which might be relevant to them. Also, generally speaking, income from property for charities is exempt from income or corporation tax. However, if you are providing significant non-property related services, then that might be seen as trading, and therefore to be subject to tax, although there are limits up to which you can carry out non-primary purpose trading without being taxed, which may well cover what you're doing. Sorry, I think I also didn't mention that on the VAT point, that I mentioned that there was VAT if the space is not defined. Also, again, if you're providing substantial non-property related services, then that might be seen as a VATable supply, because it's not property and therefore not exempt. So it might be worth, if you are doing that, putting that in a separate agreement so that it doesn't all get lumped together in the same taxable supply. And just briefly on statutory requirements, if you are planning to alter the property, either just to deal with COVID or in order to share with other occupiers, then you need to bear in mind your obligations under these various pieces of legislation. It's worth bearing that in mind early, so that when you go to your landlord for consent, you're sure that what they're going to be consenting to is something that will work under these pieces of legislation, rather than getting all the way through that process and then finding actually that you need to make an amendment to the alterations you were planning to carry out. And then finally, and obviously this is now more specific to do with, for example, subletting property, you should think about the terms of the arrangement with the other party. So one thing you want to ensure is that any costs that you incur with respect to the property are appropriately contributed to by your occupier. A big one is repair. So either you're a freeholder, in which case you have to repair the whole building, or you are a leaseholder, in which case you probably have to contribute to the cost of repair under your own lease. So the sorry, I got distracted. Yes, so there are various ways of dealing with repair. For example, if you can make the tenant or occupier responsible for the repair of their own area, in which case you have to trust that they are going to be able to do that and going to be sufficiently good at carrying out their obligations. You could also make the likely cost of repair part of the rent, just charge an increased rent, or you could charge a fixed sum per year for repairs. The advantage of this is that it's simple for both parties. There's lots there's not a lot less administrative hassle than a service charge type provision. And of course, it doesn't necessarily cover all of your costs in a given year. In some years, it might be more than the costs. In other years, it might be less. The other option is to levy a service charge type provision where the tenant or occupier makes on-account payments towards repairs. And then at the end of the year, you do a kind of financial reckoning where you see what the costs of repairs actually were, how much the occupier has paid, and then you either ask for further funds or give them a refund or carry over the money, depending on whether they've paid more or less. Obviously, that ensures that all of your costs are covered, but at the same time, it is a massive hassle to implement, and it may not be very popular with your tenant because they don't know how much they're paying in a given year. So that's something to bear in mind. There are also other costs, for example, building insurance, rates, etc. And depending on the arrangement, either, if you're passing everything on to someone, then they just are responsible for their own rates, if for example, you're passing on the whole of your property. But if you're only subletting or sharing part, then a good way to deal with this would be to assess their floor area as a proportion of the total floor area of the building, and then to charge that proportion of those costs to the tenant in each year. Also, you'll want to think about how long you want the arrangement to last for, and how much flexibility you want. It's likely that both you and the tenant will want some kind of flexibility in the form of a break night, either because the tenant is worried about whether their business will keep going or whether their funding stream will keep going, or because you want to potentially have the property back later on or to redevelop it, etc. And you also want to assess how much control you're going to have over your subtenant or sharer, i.e. what rights they will have to alter the property or to pass on their interest to another person. Generally speaking, particularly if you yourself occupy under a lease, it's probably best to have an absolute ban on those things so that you keep control. So that hopefully is a good overview of the things to consider in these transactions. For those of you watching on YouTube, you can see my contact details here, and I'd be very happy to answer any questions that you have. I'll stop the video for you guys now.